Good morning, everyone. I think we're able to resume with Mr. Hall.
Mr. Hall, my lord, yes.
Right. Good morning, Mr. Hall. As you're aware, you're about to be asked questions by Mr. Connell, who's sitting opposite you. But first, I understand you're prepared to affirm.
Yes.
Sitting where you are, could I ask you to repeat the following words? I solemnly, sincerely, and truly
I solemnly, sincerely, and truly
declare and affirm
declare and affirm
that I will tell the truth,
that I will tell the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
Thank you, Mr. Hall. Now, your evidence is scheduled for the day. We will sit between now and 1 o'clock in the morning, but not 1 o'clock in the morning. Let me start that again.
Somebody should have
We
told
will
me.
sit this morning between now and 1 o'clock. We'll take a coffee break about 11:30. We'll sit again between 2 and 4 if we require that time. But if you want to take a break at any time, just give me an indication and we can take a break.
Thank you, my lord.
Now, you seem to me to have a good, strong voice. Can I encourage you to use it? It's important that we all hear what you have to say. Now, Mr. Connell.
Thank you, my lord. Now, you are David Hall, the man who is synonymous with Curry and Brown for a lot of the evidence that we've heard in this inquiry. I start by asking you the formal question we always ask witnesses at this stage, which is, you have produced a witness statement. Are you content to adopt that as part of your evidence to this inquiry? Yes, I am. Thank you. Now, I'm going to return to the witness statement, and we'll put it up on screen and so on. And when I refer to page numbers, you'll find that the page number at the top of the page is where the electronics will take us. So I'll mention that to you now. I want to ask you, before I turn to the witness statement, and acknowledging as I start this somewhat long point, that we will end up going back to a number of issues because they crop up at various points in your witness statement. I want to ask you about one or two things. First, can I just ask you, first of all, a very general question about the form of contract that was in use here, the NEC3 with design and build provisions. At the time, obviously this is some time ago now, was that a contract that you were familiar with? Yes, I had received, done training in NEC before we started the project, and I hadn't used it personally, but I had strong awareness of it. Thank you. Now, the next question I want to ask you is focused on the role of Curry and Brown, and when I say you were synonymous with it, it's simply because you're the most common name who appears when people talk about Curry and Brown in this inquiry. So if I say you, and it's not something you did, it's somebody else did, no doubt you will tell me. An issue appears to have arisen about what role Curry and Brown played, particularly after contract signature, and what people thought was happening. And I need to put these things to you as they have arisen. Now, we have the benefit of a witness statement from your colleague, Mr. Ross, who described himself as the commercial man. Is that a fair description? He was dealing with contracts and things. Yeah, he was the senior director and was dealing with the contracts. Douglas's background is in cost management rather than project management. And we also have a witness statement from Mr. Baird, who's going to speak to us later in the inquiry, who was one of your colleagues. So I just want to put some things to you fairly generally. We can go back and look at documents later if need be. But if you can just follow this through with me and tell me if I'm getting it correct.
looking at Mr. Ross and also to some extent your statement, Mr. Baird's statement, and perhaps even Mr. McKechnie's statement, I'll start with a preliminary question. There's a lot of reference, both in witness evidence and elsewhere, to something called the technical team or the technical advisors. Now, did these phrases have any particular formal existence in the contract documents?
In the initial stages, the technical team, which existed up until the end of 2009, was under Curry and Brown, and Curry and Brown had a technical team up to that point.
Yeah. Well, I'm going to come to the detail of that. I just wondered whether, like project manager is a word which you can find by looking up the NEC 3 contract and saying there's a project manager. But I just wondered whether technical team was in that kind of category.
I think you will find, and this is from memory, it is a long time ago, that the appointment of Curry and Brown in the original phase would have included the technical team definition to include HLM, BMJ, Wallace Whittle, Buck and Associates, and others who were, that formed part of that team that were preparing the employer's requirements.
I wonder if we're speaking about the same contract. Are you asking about the NEC 3?
Well, yes.
Right, so that's a different contract.
The contract which formed the arrangement between Multiplex and the board has phrases in it such as project manager, such as NEC 3 supervisor, and so on. I just wondered whether you were aware whether technical team had some special definition there.
Yeah, I do not believe that existed within the NECT contract.
Now, my understanding from the material that I've seen, particularly Mr. Ross's statement, is that the original intention, or hope on the part of Curry and Brown, is that you would retain the team of sub-consultants, which we see in due course, after contract signature, and then carry out a role, whether you describe it as employer's agent or whatever you want to do, which would involve you having these consultants still working for you and using them and your own expertise to check things like design, compliance with employers' requirements, and so on. Now, is that the original intention?
That, I believe, was the intention prior to the procurement and contract strategy. The board went through a process of understanding how they would procure the hospital and under what contract they would use. So at the point when we were talking in those terms, that preceded the decision for NEC. It preceded the decision about the competitive dialogue process, and was assuming and what perhaps the more normal SBCC or JCT type route, which wasn't taken.
Now, things, as you said, you had a series of sub-consultants, and we'll come to these. They're laid out in your witness statement in detail and elsewhere.
Just essentially for the purpose of our notes, when you use the abbreviations SBCC and JCT, these are separate standard form or probably suites of standard form contracts in contrast to NEC 3.
The SBCC is the Scottish equivalent of the JCT effectively, and there are other forms of contract, yes.
Sorry, Mr. Cole.
What I was just looking to take from you generally at this stage, because we can go back and look at any of the details later, is that things then changed around the time, and in the sense whether it's December 2009 or January 2010 doesn't really matter for our present purposes, when the contract was signed with Multiplex, because at that time the board decided to take on the role of project manager, and they decided they would appoint an NEC 3 supervisor, who in due course was given to Capita. Is that correct?
Yes.
And the result of all of that was that, well, it was two things. One, your sub-consultants were all stood down in January of 2010.
That's correct.
And what was left of Curry and Brown's role involved yourself and Mr. Baird on limited areas of work, is that right?
It was providing project management support primarily, and Douglas providing the cost management support. There was, just to be clear, a drawdown arrangement put in place for I think two of the sub-consultants during the period of the Appendix K, which is the period from December 2009 to December 2010, for what I would describe as ad hoc support in terms of perhaps coming in on instances to cover off issues that arose, and those were with Buck and Associates and Wallace Whittle.
I'm going to ask you about Wallace Whittle because they were one of the sub-consultants dealing with M&E matters. So I'll ask you about that in due course. But if we take the generality for the moment, up until the end of 2009, Curry and Brown, and we'll go through the jobs that you did, Curry and Brown were leading a group of consultants covering a range of topics. And then broadly speaking, and subject to the point you've just made, they were all stood down in 2010 in January.
Yes, the design responsibility was passed to Multiplex.
Now, what I want to ask you about this next then is this. Leave aside for the moment any debate that there might be as to whose job it was to do what at this stage. Can you help us at all as to how the arguably quite significant change in your capacity, you Curry and Brown's capacity, was communicated to both the Multiplex side and the GGC side?
In terms of formal, no. In terms of informal, there was a quite clear awareness across both the project team and Multiplex that the people that they had been talking to through competitive dialogue, through the employers' requirements preparation, were no longer evident. We all worked out of, well, the team worked out the one office, and all of these consultants would regularly visit, and they were regularly in the facility. They were there during the employer requirements delivery. They were preparation. They were there during the competitive dialogue process and supporting the team. They were there at the point of the evaluation, and they were part of that evaluation. From the point of January 2010, those people were no longer there. So it was it would have been very quickly evident to anyone that was engaged in the project that there was indeed a change in the way that the project was being designed. The design responsibility had moved over to Multiplex entirely.
Can you remember any communications in which the description you've just given us is of people were aware because other people were not there anymore? Can you help us at all with any communications that may have taken place or that you made about saying, well, you remember it was Curry and Brown and the technical team, not anymore?
That was made clear to my mind at internal project team meetings. Alan Seaborn led the internal project team meetings that were on a regular basis. And I would suggest that was part of the discussions around that time about how we moved forward. Because we were changing from having user group meetings with HLM, BMJ, etc., which had happened up to that point, and we were now engaging with Nightingales. We were engaging with ZBP, Zisman Bauer Partnership. So that was all communicated to the team that those were the people who would be taking forward the design.
And in terms of any communications to people on the Multiplex side, including the names you've just mentioned, are you aware of them being told that things had changed?
Yes, because they were quite clear in terms of the way the contract was set up, that the responsibility for design lay with them, and the board's responsibilities were under the reviewable design data guidance limited to clinical functionality. And therefore, they were aware that there was no technical design team generally behind that, and the way they had to deal with that was by raising specific issues as non-compliances, or we used to use the term alternative design solutions. I think in the inquiry we've referred to derogation. It was the responsibility of Multiplex to highlight those so as the board could take appropriate action in terms of seeking advice on those type of changes.
The label, the technical team, or David Hall and the technical team, or Curry and Brown and the technical team, seems to have stuck after January 2010. Who would be in that? If anybody said, well, who are the technical team, David? What would you tell them?
The technical team for the hospital was Multiplex's team. If we needed to have advice from a consultant, then that would have to be specifically sought, and that would typically be done when Multiplex raised a non-compliance or derogation or alternative design solution. And there are examples of that, in the early phase. That's when I'm talking about, when Wallace Whittle came in for those short stints, and then thereafter the board appointed, when situations arose, Capita as an additional compensation event to their role to review certain design issues.
So so during the design process, any perception that you, by which I mean Curry and Brown and yourself, possibly Mr. Baird, were the technical team, would be incorrect, would it?
If you were referring to contract administration, project management, no, it would be correct. We were technical in terms of those activities, but not in terms of design.
And who I mean, in physical terms, but by this stage, by the time you've moved into the design phase, who physically from Curry and Brown was around and about on the project?
There was myself, and there were some of my colleagues, Graham Thompson, who one of our activities and one of the responsibilities I had within the project team was to look at program management and to look at an NEC contract. You have to undertake a review of the program every month, and the project manager named in the contract, Peter Moyer, would have to accept it. Graham Thompson and I reviewed the contract program on a monthly basis and provided technical advice in terms of that. My background as a chartered construction project manager leaves me qualified to do that particular activity, and that would be something that we would do. So we were technical in that sense. That was project management, and so there was Graham. We also had some people that were assisting in terms of some of the clinical moves and the like. So Paul Ferry was involved in that as well. Again, that was a project management support function. It was not a design function.
I need to continue this theme with you, I'm afraid, because I need to seek your comments on things that others have told us about this, if I can. Perhaps one view, the most striking one, is that you know who Emma White was?
Yes.
So she was the lead architect, the lead consultant on the multiplex side, whatever phrase you want to apply to her. And she seemed to think that Curry and Brown were still the technical team, and indeed that you were reviewing M&E design.
Right.
Why would she think that?
I would put the responsibility for that on Multiplex. Emma White was part of their design team. She was working to their design managers. There would be Darren Smith, Gavin Burnett, and Jim Murray. Were three design managers, and they were responsible for communicating everything to their design team. I lost count probably of the number of times I reminded those three individuals that the board's responsibilities were to sign off on clinical functionality and that the board were not reviewing the technical design.
I'm going to ask you about clinical functionality a little later so that we get a definition of that. But rather than stop that. Right, well, so that's fine. So she's on the multiplex side of the equation. Did you work with Francis Rath?
Yes, I did.
Now, occasionally or regularly?
Regularly. We sat in the same office for 5 years.
Now, in the course of giving evidence here, she was asked, well, where did the board go for technical advice on M&E matters? And her first reaction was to say, well, I would go to David Hall. Now, why would she think you were dealing with M&E matters?
I was the conduit for M&E matters. So, for example, if there was a question mark over M&E, quite often I would be asked the question and I would then communicate with the appropriate people. Post 2010, of course, that was multiplex. So there will be emails from me, for example, where people have raised questions. I have actually taken their question, put that into the design management process and asked multiplex to come back with their responses because they were responsible for the design. So I was acting in that role of coordination, but I was not, I'm not qualified, to do M&E.
I mean, I think it's clear from your witness statement that you don't have any qualifications as an M&E designer or indeed as an engineer.
No, I don't.
Francis Rath is asked, well, who's looking after these issues during the design process? And she says, well, David Hall, Peter Moore, Alan Seaborn, David Loudon. Now, none of these individuals have technical qualifications in M&E matters, is that right?
Correct.
So she's then asked, well, where would they get the technical expertise from? And her answer is, well, I assumed there was a technical team. Now, again, it's just a bit puzzling that the position you're setting out is very clear and focused, but somebody you're working with all the time is assuming that behind these individuals there's a technical team. Can you help us at all in that?
The assumption, to my mind, I don't understand that assumption. As I say, there was clear evidence of who was involved from the Curry and Brown side, and that did not include any technical, support beyond 2010, when the final piece of work by Wallace Whittle was done.
Well, maybe you've given us the answer in response to an earlier question, but I'll just continue with this meantime. Mary McLeod, is that somebody you worked with?
Yes, it is.
Again, in physical location terms, were you close to where she was based?
Yes, she was in an individual office, but I was in the open plan office immediately outside it.
Now, when she gave evidence, listeners may have got the impression that any technical issue that cropped up, she popped along and you gave her the answer. Would that be an accurate description of how things happened?
She may have come out and asked me a question. I didn't. Unlikely I would have given an immediate answer. I would have gone and sought the answer. Part of my role was to support the team. Bit of an analogy, but when you're putting together a team for these things, it's a bit like putting together a football team. You need people with lots of different skills. You've got your striker and you've got your defenders. So people, in this sense, we've got people who have. I mean, Mary was a business manager for the NHS. Mary was not a construction person, and she wasn't necessarily familiar with all the processes and everything else in a construction project. I had 25 years of working in the construction sector. So my experience about knowing who to go, where to go, and who to ask questions of was probably lent upon by that team. As I say, to say they popped out and got an answer from me is inaccurate, because I wouldn't have the answers, but I would know where to get the answer.
Let's see. I come back to the make sure I'm getting that correctly. Mary McLeod was in charge of one part and Heather Griffin another, right?
Yes.
And were they both in the position of being essentially healthcare administrators? Because they were given the title of, deputy project manager in charge of parts of the site.
They were project managing. Mary was project managing the children's hospital. Heather was project managing the adult hospital. Much of their responsibility was about interaction with the stakeholders, with the clinical users, and about organising the user group meetings and doing all that activity. And I always treat it a bit like an hourglass, trying to give you an analogy or a description of how I would explain this. But if we have the construction contract at the bottom of the hourglass and we have the users at the top of the hourglass, you have a pinch point in the middle, and that's where your project managers sit. So in there, you need to have people who have the skills both to work upwards into the users, understand the clinical aspects of that, and gather all of that information. And you also need people who know how to interact with contractors and construction professionals. So basically, when you put the team together that sits in project management, it's never one person, it's a group of people. And you use the different skills that those people have to create a strength that is greater than any of the individuals. And that's really how it worked in the sense that a lot of my experience would be about how the client would interact with the contractor, and that's where Peter Moyer effectively sat as well. Peter was the project manager managing the NEC contract. My main interface, therefore, was with Peter and into Multiplex. But like anything, I always work on a principle of awareness versus real knowledge. The majority of my job was about having awareness. I don't undertake a lot of the tasks, but I'm aware and I'm managing and I'm coordinating. So I try and keep my mind open to everything. In every meeting, I listen to everything that everybody's saying in order that I've got the greatest awareness of what's going on. But I'm not necessarily into the detail of absolutely everything. In a hospital of this scale, that would not be possible for one individual. You rely on a team approach.
So Heather Griffith and Mary McLeod weren't project managers in the sense that you might find on any building project dotted around the country, but they were more focused on communications, as you put it, towards the top end of the hourglass that you described.
If I can put it another way, and I'll help you out here, I think in my current role where I am, I have a team where I've described development managers and project managers. And I would say that the role of development manager, which is all about developing the brief and taking the project through its initial stages and understanding the requirement and the business case, was where Mary and Heather's strength sat. And then the project management piece sits after that. And then, but you keep the two together so you don't lose the train throughout the thing. So I would say they were closer to what I would describe as a development manager.
Well, I need to ask you about one or two particular documents. Can we have bundle 46, volume 1, page 98, please? Get this the right one. Now, if we just scroll down onto 99, I think, to see the start of this. You'll find here that there's an email chain involving Mary McLeod when she's passing on information about HEPA filtered rooms. You see that at the bottom of 99. Now, it would appear she thinks she got that information from you. Is that possible?
I don't. I can't comment. I don't believe so. I'm not familiar with that email chain whatsoever.
I'm just wondering. I won't ask you after this passage of time to remember every email that we show to you, and please do just tell us if you don't. But trying to square the circle, if people had a question about M&E and ventilation, am I right in thinking from your earlier evidence, they may have come to you because you were the person that was known to be the point of contact, and you may then have got information from somebody else, depending on what the topic was.
That's possible.
Is that the kind of thing that you did?
Yeah. What I would say in this instance is, and it's a general comment, that in terms of the amount of interaction I had, it was greater in the adult hospital, and I think I said that in my statement, because Francis Rath is a building surveyor, has a construction background, and was closely involved in the children's hospital. So Francis and Mary worked very closely together in much of the children's, and as a result, a disproportionate percentage of my time was more to support Heather, because Heather didn't have a similar backup on that side. So the majority, I would have probably more interaction with Heather than I had with Mary.
Another name that crops up is Miss McCluskey. Do you remember her, Miss McCluskey?
Yes, she was the nurse advisor on the project.
Could she have thought that you were the person to go to ask about ventilation issues?
Well, as I say, in a similar way, that if there was requirement to gain information, I often was the conduit into multiplex. And similarly, you'll find that multiplex will say the same thing. If they needed something, they would come to me as well. And Peter Moyer. Unfortunately, as you know, we can't speak to Peter.
No.
Speak on
It's
his
not,
behalf.
not available to the inquiry.
Yeah.
I'll just leave it at that. Jackie Barman Roy, is that another name you recall?
Yes, infection control nurse, Jackie Stewart.
Yeah. I just want you to have a look at a couple of documents just to see if you can help us. And if you can, fine. If you can't, equally so. Can we have Bundle 14, Volume 1, Document 2 at page 21? Now, here we have, as you quite correctly point out, in her name was Jackie Stewart, in 2011, saying in an email to various people, I'm meeting with the M&E chaps next week to go into some more detail. Do you have any idea who the M&E chaps would be? Because you don't have any on your team by that time.
At 2011, that would presumably be ZBP.
You would take that to be a reference to Multiplex's advisors on M&E?
Yes, it could be either. Well, it could either be that, or it could be Multiplex's M&E managers. So there was the likes of Darren Pike and Colin Grindley and others that were in that role.
Okay, can we just go on to 25? We may find a similar answer. Let me just see. And if you go to near the foot of that page 25, you see Jackie Stewart again saying the technical guys were wondering if you were available to meet them. And she's saying this to Craig Williams. And they're going to outline systems and ventilation systems generically. So this is 2012, so it's even further on.
Yep.
Who can you help us at all as to who that might have been, the technical guys?
I've obviously not seen the email before, but I would suggest from that, again, I would expect that would have been Multiplex, and it would have been Dan Pike, Colin Grindley, etc.
Thank you. So if we do come across, and we may touch on a few as we go through your witness statement, documents in which you appear to be involved in a variety of technical issues, you're simply helping out in your project management role. Is that what we should take?
Coordinating, getting the right people in the right room at the right time to talk. I mean, when it says the technical guys, it could have included me as the facilitator of that.
Just before we leave these sort of introductory discussions, I just want to ask you about Wallace Whittle.
Yes.
Now, they were the M&E consultants, I call them that, the M&E engineers who were part of your consultant team prior to the change in early 2010. And they were one of the consultants who were then stood down, subject to the point that I'll come to that you've made already, in 2010. So that they weren't then routinely participating and advising. And we have Mr. McKechnie coming to speak to us later in the inquiry. Well, let me just ask you the general question. As far as you're aware, did Wallace Whittle, as a consultant for Covey and Brown for GGC, design any of the ventilation systems?
No. And not until they bought, to just confuse it further, bought over ZBP.
Right, yeah. That's why I preface my question by saying, in their capacity when acting for Covey and Brown, who were acting for GGC.
They did not design.
Now, the initial perception that one might get then is that when you get to around January 2010, Wallace Whittle, as an advisor to GGC, would disappear off the scene and not be expected to be around because, like all the other consultants, they were there. But you told us there was a provision whereby they could be asked to do specific tasks if a specific request was made. Is that right?
That's correct.
We've had some evidence from multiplex witnesses who were asked, about a number of these structural arrangements and how Wallace Whittle fitted into them, and they seem to recollect involvement of Wallace Whittle at some point later in 2010 than January. Is that possible?
Yes.
Mr. Pike thought that they were involved in some kind of M&E reviews in August 2010. Do you know anything about that?
Yes, I do.
What was happening there?
Okay, so the purpose of the reviews was for Multiplex to present any issues that they believed did not strictly comply with the employer's requirements, and that they needed to consider an alternative design, to deliver the solution. So that there might have been competing requirements within the employer's requirements, for example, and those competing requirements might require them to go up, not to comply with something entirely. So therefore, they would become effectively an alternative design solution, or as known as a derogation. So the purpose of it was that throughout the period of 2010, ZBP were developing their design. Effectively, what we then did was I'll call it a gateway review of the M&E design. So there was a short burst of presentations in the August on a variety of topics, ranging from fire detection to smoke removal to water systems, ventilation, heating, all the rest of it. So Wallace Whittle came in to be presented to and to comment upon issues that Multiplex considered did not necessarily fully meet the employer's requirements. And that was the purpose of that. And I believe there was actually a further set of that.
Okay, well, let's just pause on one for the moment, and I'll give you the opportunity to add to your answer, because we're obviously keen to know your evidence. I was just going to ask you to look to another document which you may not have seen recently, but it shouldn't cause any issue for you. Can we have bundle 31, page 111? Now, I've put up this page of the document. Have you got it?
Yes.
Yeah, thank you. Primarily because this page, although it doesn't mention you, sets out who's at this meeting of something called the Project Management Group.
Yep.
Do you remember participating in these?
Yes, I do.
And we see there that you're among those present, with Mr. Moyer, Mr. Ross, in fact, Mr. Ballingall, Mr. Pike, and various others. And then there were some apologies. And I just wanted to ask you about one area where DH, which I think is you, appears, which is on the next page, 112, about third paragraph in. Now, can you just help us what's happening here? The workshops to review the architectural drawings had worked differently from the M&E reviews. Most of the drawings hadn't been issued, they'd been presented on the day of the workshop. Now, this is September 2010, so you're well into the design year, if I can put it that way. Can you just help us understand what's happening here? Is that anything that Wallace Whittle might have been involved in?
Well, the architectural drawings would not have involved Wallace Whittle. Right. So I was noting that the workshops to review the architectural drawings have been different from the M&E reviews. So the M&E reviews are the ones that we've just referred to in August, where there was presentation by ZBP to Wallace Whittle. Wallace Whittle would have provided comments back on that. So that's the M&E part of that. The second part is a different
A different issue.
And would not have involved Wallace Whittle.
I think you were about to tell me about, we can take that document down, thank you, about possible other involvement of Wallace Whittle after the January of 2010 when they otherwise stood down. Just tell us an outline about that and we'll ask you.
So I was obviously alerted to this question from ahead of it, so I have had time to consider this. There were in my memory, and obviously we are talking some time ago. I think there was 3 interactions in total by Wallace Whittle. Interaction number 1 was probably in the spring of 2010 and involved a discussion around high voltage connection to the hospital with Scottish Power, etc. So that was something that, that was the first interaction. The second interaction was a review of the design progress on Appendix K in terms of the MEP, and that's the one to which I think Mr. Pike referred to. A series of workshops on a number of topics. They would have been attended by a number of people in the board, including Peter Moyer, Alan Seaborn, myself, potentially Hugh McDermott for some issues, Ian Powrie for other issues, as well as Wallace Whittle, who attended that and commented on those. And then I believe there was a final shorter session in late 2010, probably around about October, when Wallace Whittle had a further presentation on what was effectively going into the final Appendix K.
When they were doing these things, they were doing them, as a sub-consultant to you?
Yes, because it was that was the appointment. I think there was an allowance within the letter, from memory.
So what was their function in the events that they attended?
Right. So as I said, they were only looking at issues that were raised by multiplex as potential areas where we were looking to move away from the employer's requirements. So if it was something that was fully in accordance with the employer's requirements, it would not be presented and discussed. It was only where multiplex highlighted this was out of line, or we needed some discussion on this to make sure that everybody was content. And what they were doing is Wallace Whittle were then providing the board with advice on whether these sort of issues were acceptable or not.
My fault entirely. You mentioned, as you recollected, 3 interventions by Wallace Whittle in the course of 2010. The high voltage connection, the design progress on Appendix K, and
the last one was almost like a final sort of review of the Appendix K. So they came in the August, made comments, and then obviously ZPP went off again and did some further work, and then there was another almost like a wrap up review.
Thank you.
Another document has only recently come to my attention, which I need to put to you again. If you're not familiar with it or you can't help us with it, you're very free just to say so. Could we have Bundle 43, Volume 3, page 1280? This is headed. Well, it's a multiplex document for a start. I'm just calling them multiplex to avoid getting into the different names, Mr. Hall. So forgive me for that.
Yes.
And it says New South Glasgow Hospital's response to comments on Appendix K, M&E drawing, and then there's an introduction saying a number of drawings presented, reviews high level of strategic nature, with detailed discussion of specific issues. Drawings would be developed to a more detailed level for further review, and then there's some comments on different issues, which most of which we needn't trouble about because they're on topics that the inquiry isn't focusing on, like maintenance or well, we have been asking about maintenance, but medium voltage systems, for instance, We don't need the technical detail on that. First of all, is this something you've seen before?
I honestly can't remember.
Can we just look at a couple of the items? Can we scroll through, please, till we get to item 27? I'm afraid I don't have the precise page reference. Thank you. We're now on 1284. And you see an item headed isolation suite ventilation.
Yes.
And there's a comment that they're gathered together within a common plenum, within a plant room, etc., mixed with fresh air, then extracted via another set of fans. And the comment is, this is non-standard. So is that the kind of thing that Wallace Whittle apparently were commenting on? Because the heading, of course, is Wallace Whittle comments.
Yes, that is the type of thing, because these are obviously issues that have been raised by Multiplex as potentially having some, question mark around compliance with the employer's requirements.
And then the next column is the Brookfield or Multiplex response. Can you remember whether there was any discussion about the actual design of isolation rooms? Because this is actually commenting on a supply issue, how the air is going to get basically from the plant room. If you don't remember, that's not an issue. Just tell us, please.
Do I remember there being discussions around isolation rooms? Yeah.
Well, at this point.
At this point, probably not.
And then there's another paragraph headed renal dialysis ventilation. It said renal dialysis is taken as 10 air changes an hour, which is a category of a treatment room. Discussion as to whether this can be reduced. Further investigation required by ZBP via the SHTM risk assessment and other precedents to be utilised. And then there's a Brookfield comment saying, we've discussed this with the board, it may be relaxed.
Yeah, that's one I am more familiar with,
right?
To be honest. So this is one we're working with Heather. One of the issues that we had from the user groups on the renal dialysis suite was their experiences from the Stob Hill and Victoria ambulatory care hospitals, where we had reference from those users that the 10 air changes per hour for a patient sitting for 3 to 4 hours getting renal dialysis was drafty and was creating an issue in terms of patient comfort. And they asked us, as a lessons learned effectively from those hospitals, to look at the implications of reducing that air change rate.
Do you know what the outcome was?
From memory, this is one that was referred to Peter Hoffman for his advice. And the ultimate result was, I think, if I remember rightly, the air change rate in the renal dialysis suite was reduced to 6 air changes per hour.
Okay. And can I just go, just while we're here, onto the next page to point 30? It says, plant has currently been provided with 25% margin. Now, we've had some evidence earlier in the inquiry about how you should design ventilation plant with a margin because it degrades, even if maintained, because things clog up and then it doesn't produce precisely 100% of what it was doing. Do you remember any discussion about this?
Yeah, absolutely. Obviously it was there. It was in the employer's requirement for the 25% margin. And what was the discussion there was about the final distribution. I mean, obviously, the biggest problem in adding to ventilation at a later date is either the plant or the vertical movement, because it's very difficult to increase the size of a riser. If you're refurbishing or refitting a floor, it is much easier to then expand the ventilation horizontally. So the bit that refers to there, the final distribution does not have this margin applied, is on the floor, not through the core of the building, because you can, obviously, if you take a ceiling down, you can put a wider duct in. That's not generally a problem. So there's a common sense approach in what's been done there in terms of that efficiency, because that makes it more efficient as well.
it probably raises the general question that we've raised with a number of witnesses, which you've picked up on, that changing ventilation, particularly in a riser and in plant rooms and so on, after you're well into the process of getting the hospital up and running is difficult. Is that
Yeah,
fair
it's
comment?
future proofing, and what was allowed for was either not always 25% was given in the plant, because that would be extremely inefficient, and would cost a fortune to run potentially, and actually might not run properly. That's my understanding of it. I'm basic mechanical engineering here from learning and listening. I'm not a mechanical engineer, but. And similarly, I mean, obviously in the risers, so in some cases in the plant rooms there was additional space left rather than the plant actually having the additional capacity.
We can take that document down. Thank you very much. Apologies for showing you things that you've not necessarily seen for some time, but it's the nature of this inquiry that the number of documents that A, exist and B, emerge is significant. I want now to take you back to your witness statement and pick up on any issues that arise using the format and order of the witness statement as a guide. And we find that starting on an electronic page number, which is 196.
Mr. Connell, you said you would come back to clinical functionality.
I will.
There may be an appropriate moment for you to do that.
There will indeed, my lord. The first time it appears that I've spotted, we shall ask the question.
Very well.
It might be easier to do it in the context where my lord sees the sentence or whatever, where it appears, rather than take it simply as an abstract question. What you've done here, obviously, is you've set out your understanding in the way that has suited you to do, and inevitably that means we will trip up over points we've already discussed as we go through, but that can't be helped, because even on the first page we see in paragraph 4 you're talking about Curry and Brown's reduced remit following the award of the contract, because that reflects the fact that you didn't then have a whole troop of sub-consultants regularly. And of course, we're not talking necessarily about one individual per consultant, maybe a number of individuals. You don't have these anymore. You only have a much reduced operation, as you've described to us. You go on the next page to explain your experience. And although you've done various things in the past, you describe yourself now as a project manager. Is that where you see your skills lying?
Yes, I'm a chartered construction project manager.
And you say you worked on various complex projects, and you instance a couple of these. Anything as complex as the new hospital prior to that?
To be honest, no.
No, there's no harm in saying no. I'm just asking the question.
I think if you look around Scotland, you'll find it hard to find a more complex building.
And so we can have context to your subsequent answers. We should probably look at 198, because there you set out the dates during which you worked on the project, from September 2008 until April 2015. So that, as you point out, between handover and live occupation.
Yeah. I had some ad hoc recalls from probably April to September.
I think you were focused on various things after that.
Yeah.
But that, and was Peter Moyer your principal contact?
Peter and Alan. Yeah, I mean, in terms of, obviously my role was very much project management. Peter was the project manager. He delegated activities for me to undertake.
You'll understand that when the inquiry formulated questions from which you then created this statement with assistance from those you needed, the inquiry didn't necessarily know who did what, when, why, and hence you may have been asked questions that weren't in your remit. But I note in paragraph 10, you're keen to make the point that your role was centered around coordination of project activities and you did not undertake any design responsibilities at all.
No.
So that's your, basically the theme which then runs through what you tell us later on.
Yes.
In paragraph 12, and at this point you're giving us a general outline, and some of the points we return to later in your statement. You say that in the first year after the contract, so that's the first year of the reduced role, if I can call it that, your time was split between supporting and coordinating the process of design development and contract administration of the lab building, which we don't need to concern ourselves today. When you say supporting and coordinating, just so his lordship understands, I mean, what are you actually doing? Because the word design appears there, and you're supporting and coordinating it. Can you make sure we're absolutely clear as to what you were doing?
Okay, so the multiplex design team had come together at this point, obviously. They had prepared their bid and everything else. They had gone through the competitive dialogue process. They were now engaging. Sorry.
Mr. Hall, you do speak quite quickly.
Sorry, I come from Glasgow.
Could you just start again? The question is, what do you mean by supporting and coordinating?
Okay.
And I think we're still at about paragraph 12.
Well,
Yeah.
yes.
Okay.
So could I ask you to start your answer again?
Okay, no problem. So in terms of supporting and coordinating, Multiplex had now been awarded the contract. They were their design team had met some of the user groups previously, but obviously we're now coming into a much wider thing because they were having to go into every single user group. So we have to pull together the Multiplex design team, the Multiplex design managers with the end users and all the stakeholders in the user groups in order to develop the design of the hospital from what was a bid stage into something that could actually be contracted at the end of 2010. So it was sitting in, and as I say, I talked about that hourglass. It was sitting in that middle of that hourglass, making sure that we were getting the right people from the health board, talking to the right people from the design team.
And were you in that role contributing to the design process, or were you just organizing it?
Contributing in the sense of trying to ensure that the designers and the stakeholders understood each other. Often when you are working with groups of clinicians, nurses, physiotherapists, all those type of people, they are not familiar with how to inform a design team. They need assistance to make sure that the right questions are being asked and the right answers are being sought. So you are facilitating and sort of trying to create the environment in which the correct outcome, is arrived at. You're using your experience of having worked with stakeholders, worked with designers, and understanding where the gaps are. Many, lay people find it hard to read a technical drawing. And you need graphics, you need images. So you're talking to the designers about how they are presenting, how they are getting their message across. You're trying to encourage them to use more visuals, all of those type of things to make sure that the people understand what it is that they are commenting upon. Because if you actually sometimes give people a blank plan, they'll actually see nothing. So you need to give them more than that. So it's all of that encouragement to make sure that the design process is working correctly.
Yeah, because this is, we'll touch on the user group meetings. As I understand it, these were primarily focused on basically layout and equipment and the other requirements that you had to have in terms of gases and machines, where they're going to go and stuff like that. Is that what was being discussed?
That is primarily what was being discussed. There are obviously reference to some of the guidance and all the rest of it. Again, often a difficult subject to discuss with end users, that there's guidance there that they have to work with. They want what they want. And then you say, well, you can't have that because the guidance says that's not possible. I don't want to make everybody laugh, but I actually sat in a meeting on one occasion where one of the clinicians said, well, the SHTMs are just balderdash, because the SHTMs wasn't giving him what he wanted. So you have to balance that whole piece that says that the end users want what they want, but they also have to have the advice and that's what the designers should be doing. The designers are responsible for designing in accordance with the guidance, so they should be pushing back. But there's always that middle ground, and that's what, again, the board's representatives or the board's team would have to sit in the middle of and try and manage that.
What we're discussing here are the user group meetings.
Yes.
Yeah.
And I think you say in paragraph 14 that the person you primarily were supporting was Heather Griffin, for the reason you indicated earlier, that
Correct.
Mary McLeod had more assistance from Francis Rath and Heather didn't.
Yes.
And then you go on to set out there what you deal with during the construction phase, which is later on, and then your tailpiece is about Group 5 equipment installation, which I gather is certain specialist equipment that the board had to get in place, and it's not a topic we're
No, I
concerned
mean, it's MRI scanners, CT scanners, all of those type of things.
right. And then I think, for the reasons that you're probably beginning to spot by now, the questioner who has led you to produce this statement then asks again, well, just let's get this quite clear. So you give us another answer in paragraph 15. Contract management in support of Peter Moyer is what you're doing. Program reviews you mentioned to us earlier to support the board, and facilitating and managing the design reviews for clinical functionality. Now, here we have clinical functionality. Can we just be clear what you understand clinical functionality is when you refer to it as something that was done at that time?
Yep. So clinical functionality is about having the facilities in the room that allow the end users to use it in the way that they have described and desired. So do they have a sink? Do they have a bed? Do they have the medical bed head with the correct gases in it? So that is the review. Does the room have a light fitting? The technical design of all of those elements and the systems that lie behind the wall are the responsibilities of the design team to comply with all of the requirements that are set out. So the board are signing off. The board could only sign off that because the board, that was the skill set that sat in the board team, and that was set out in the contract. So there's the contract did state clinical functionality. So if you want water, you need a tap. So is there a tap? But the system to deliver safe water to that room was down to Multiplex.
Now, we're going to come back to this because it crops up repeatedly, but let me just ask you generally at the moment. You say on the next page at the top that Multiplex was responsible for the entire design of the hospital. However, the board had a responsibility to review clinical functionality, and you had delegated authority from Peter Moyer to do that. And then you say you weren't involved in technical commissioning, witnessing, or validation, which are things that probably come a little later in the process.
Before we leave clinical functionality, there will be a contractual definition of clinical functionality, is that right?
Yes.
And the contract, as it were, presumably gives a power to the employer to insist on clinical functionality as construed by the employer?
I think it's almost the other way round, in the sense that it's limiting the responsibility of the employer in terms of what they are signing off.
This may or may not become important, hence we're kind of pausing on it now, Mr. Hall. That I mean, I was about to ask, well, how does anybody know, any of the participants in these meetings on both sides of the table, how do they know that this definition is being applied to the power to sign off?
I think, as I said before, I lost count of the number of times I repeated that to Multiplex on behalf of the project team.
So you think it's
in the contract?
It's in the contract. Well, I'll just ask the follow-up question then. From your recollection, was it clear to Multiplex what the limits were to the signing off?
Yes.
And was it clear to the other participants from the GGC side what it was that was being signed off?
Yes.
Now, you say you told Multiplex repeatedly. Can you remember discussing it with those who are likely to be interested from the GGC side?
Yes. I think some of them in their witness statement or in their evidence have tried to describe, without using the term clinical functionality, they've tried to describe what it is they thought they were doing, but it is actually set out.
I'm not sure whether my lord has anything else on that point at the moment, because we can move to another topic.
Right. I obviously will have to look again at the contract documentation. I just have a little concern that those involved from the GGC side in the user group meetings may or may not have understood entirely what they were being asked to do.
Well, my lord may be right. My note on the matter, in effect, says that the user group meetings were known to deal with, and my attempt to deal with it was, what kit you need, where it goes, can you fit it into the room, what machines you need.
That is clinical functionality.
And so on. And it was a matter of general consensus that these user group meetings did not deal with what I might describe as M&E design.
That is true. We have heard evidence on that line.
This is a different take on it that we have the benefit of Mr. Hall helping us with. We'll probably return in a way to this topic a little later again. I'd like just to follow the sequence of your witness statement, so because it'd be easier for us to understand why we get to different points at different stages. What you set out on page 200 is turning the clock back a little bit now. We're talking about appointment as lead consultant, the documentation led by Mr. Ross, and the job that you describe in paragraph 17 is a task before the contract was let, because you were developing or working up, whatever phrase you want to use, the employer's requirements. Now, I may be crediting you, I'm not sure correctly, when I have a note that someone described the employer's requirements are what, not how. Is that your phrase, or is that one that I've incorrectly picked up?
I'm not sure if it's my phrase, but it probably is quite true, because it's setting out what you require, but it is not how.
So the employer's requirements say, well, this is what we want, But how you get there is then a matter for you as the design and build contractor. Is that
Correct.
right?
Yes.
They're just in
general terms.
In general
Yes.
terms. I'm keen as we move through this that we make sure we're understanding the different stages. Because in 18 you talk about the change, and 19 on page 201 you continue to talk about the change. The way you put it halfway through paragraph 19 is the design services provided by Curry and Byrne in the initial pre-design stage were not extended, with responsibility for technical design forming part of the multiplex contract. Is that the way you see what happened?
Yes.
And you didn't have the team in effect because you no longer had the design responsibility.
That's correct.
So, in effect, you're describing a situation there that as at, let me just say January 2010, the board didn't have, unless they specifically called them in, M&E design people daily involved in the processes that were then going on.
Well, they did in the sense that they had bought that from Multiplex.
Right. But, okay, let me just split this then into two. There's Multiplex and there's the board. So far as the board are concerned, they are not then employing anybody as M&E design specialists, for instance, for routine involvement in the processes that are going on. Is that right?
They did employ Capita as the supervisor role, which included, review and certification of the construction progress of M&E.
Okay. Well, let's just stick to the design phase between January 2010 and essentially the end of 2010. During that phase, am I right in understanding that the board did not have routinely on its team M&E design engineers or anything like that?
No.
Thank you. In fact, at this stage of your witness statement, you actually refer to the letter that is called the revised fee agreement, because that's a letter which actually starts talking about how many hours you need and from whom and how they're going to be paid. I suppose we should just look at that for reference. It's bundle 17, page 2870, where this is addressed obviously to Mr. Ross because he's handling the contracts side of things, and refers to dialogue, and then says, well, here we are, split into two, new lab project, project management support so much, cost management so much. The figures don't matter for our purposes. New adult and children's hospital, 57 weeks commencing January 2010. Period for conclusion of contract, that's done. And then project management support based on input of 3 days per week by David Hall. Cost management, 2 days, 2 cost managers rather, and then various other provisions giving a budget total. And if we just go on to the next page, there's a note, inputs by David Hall and Mark Baird will be developed over the next 2 or 3 weeks based on attached schedules for design development and construction works in the lab, because this was going on sort of in parallel, wasn't it, the laboratory construction. Inputs by cost managers will follow requirements and so on. And Mr. Moyer says the kind of thing that you often see, which is we'll need to manage this within an agreed financial envelope. And they're considered a ceiling and so on. And the suggestion is that you and Alan Seaborn and Mark Baird meet with Mr. Moyer to talk about what is envisaged will actually be done. Is that right?
Yes.
Thank you. I think we can leave that, because obviously we have the document And essentially what you say in your witness statement is, subsequent to that, you were aware that you had discussions with them, but you can't ever remember taking those discussions and creating some kind of when within the.
It was much flexible than that, to be honest. I mean, it was it was constantly a moving feast in terms of what required to be done.
Then in page 203, you turn to a slightly different topic, which is the project time frame, pre-design till April, competitive dialogue to September, bid evaluation till October 2009, and then design and construction phase from 2010 to 2015, including the initial design process. And you go on to say you're going to explain what you did here. Now, we've touched on Heather Griffin and Mary McLeod and their designation as project managers already in your evidence. What did you understand Frances Rath's role to be?
But Frances had a significant experience in healthcare projects. She carried a lot of knowledge of the Southern General Site, and she was definitely acting in effectively a project management support function, supporting on the development, particularly of the Children's Hospital.
So another organizer rather than somebody with technical input. Is that fair?
Yeah. But with more experience than Mary, again, in terms of dealing with contractors and those type of things. So in effect, doing a similar role to myself on the Children's Hospital.
Sure. I'm just walking you through some of this, Mr. Hall, so that His Lordship gets an understanding of the way the different stages worked, and we understand some of the phraseology that has cropped up from time to time, which we need to make sure we understand, because we're sitting outside the box and a long time after it was created. What you then do is you take the different stages that you've outlined on page 203, and you then touch on these in the subsequent paragraphs. And you list on page 204 the different sub-consultants that you had, and then you turn to employers' requirements and exemplar design. And what we're going to see is you explaining what these mean to the inquiry by means of your witness statement. In paragraph 30, you explain about the employer's requirements, and you say your role was providing project management support. And then you touch on exemplar design. Now, that's a phrase that has popped into various pieces of evidence that we've heard. In terms of this project, can you just try and summarize for His Lordship what exemplar design was meant to do? What was the idea of having something called an exemplar design?
The idea was to effectively, you could write it all out in words. The famous phrase, picture paints 1,000 words. So the exemplar design was meant to paint a picture to help people visualize what it was the board wanted. So you have a kind of massing element which says, here's the entire, what it is we need, but then you focus in on certain elements of that in order to give examples of how it might work. I can't remember the exact number. I don't know if I wrote it down, but there was a number of departments, maybe 11 or something like that.
11, I suspect you're right about it. 11,
Yeah.
Mr. Hall. Let's just take 11.
I think there was 11 departments that were looked at, and you started to look at how you would lay out those departments, what type of facilities you'd want in them, what adjacencies you would want in those departments. But it was purely about trying to express the employer's requirements in a visual form, trying to give people a feel for what it was that the board were wanting to achieve. So, but it wasn't creating an entire design for a hospital. It was painting pictures about certain elements. if that's the best way to describe it. Don't know if that's helpful.
Let me just tease this out a little bit. The exemplar design, if I understand it correctly, is just a possible proposal which a bidder may or may not choose to follow. But it's a hint as well. It's more than a hint.
Starting point.
You say it's what the employer at the pre-competitive dialogue stage thinks it wants.
Yeah.
Now, I think we know in the case of the Queen Elizabeth, at the level of massing, there was in fact a change from what the GDC thought it wanted, and what it decided it did want. Am I wrong about that?
Right. I think where that's coming from is that the 11 departments were produced in isolation, right? So if you imagine you weren't building anything other than one department, this is what you might want, right? But once you try and mass 90 odd departments together into one building, you then end up having potential compromises, changes, tweaks, and all those sort of things. So the exemplar design laid out for those 11 departments what perfection, if that's the right word, as it was understood at that point, might have been for that alone. But when you put all the pieces together, it's not possible to create perfection in every place, and there is always the piece of compromise that says, well, because of the shape, because of the interaction, because of the adjacency, we need to move that, do this, and so you never actually end up with that in. So those 11 departments were produced in isolation. They weren't into the mass of a building because the mass of the building hadn't been designed. So that's probably the difference between, what you might have as a discussion. The other thing is, of course, that people's minds develop because you do the exemplar design with one set of designers who put their ideas into that. But once they come back to the same users in a second series of meetings with a different designer, you might get better ideas rather than what was in the exemplar design because people have thought about it since they've, their minds have moved on. And it's a year and a half later. So it really was just painting a picture of what the board wanted and you're right that the learnings of that were used by both the user groups and the eventual designers, Nightingales, to advance their design.
It's probably not critical to any of the questions we have to turn our attention to, but I would like just to understand what is the information that the potential bidder, is getting from the exemplar design? I mean, you've said
they're getting
an indication of massing and 11.
I think it's more. It's probably it's more about flow and operation within. How does the patient flow through the department? How how is treatment done within the department? What facilities are required? So if you have critical care, where do you have your nurse station? Visibility, how does the patient come into the critical care department? What do you have high dependency? Do you have intensive care, and how does it flow through? So I think that's the type of information that the bidder is trying to get from the thing. It's about understanding how the departments will work, because there's been work done with the user group to say, if you laid it out like this, would this work for you? So that's the example of how that department might work. Now, that would be developed and changed in the next stage, but that was what it was setting out. And that's what the bidders were using it for.
Thank you.
And I think you said about 11, including an adult ward and a children's ward, as far as you can remember.
Yes.
And obviously there were many adult wards.
Yes.
I think I'm right in saying that your witness statement indicates that while something like a sample of 11 was taken, the final total areas, if you can put it that way, was somewhere in the order of 96.
Yeah.
And that's the point you were making.
Yeah, I mean, and some of those departments are quite small, 3-4 rooms, audiology, things like that, so, and other ones are very big, wards being the obvious mass.
So you deal with that on page 205. You explain that these were just samples, and you explain in paragraph 34 that to get to the exemplar design involved lots of meetings between a project team and proposed end users, presumably in the kinds of areas that were being used as the samples.
Yes.
And you describe your role during all of this as a facilitator.
Yeah.
And you're asked in paragraph 36, what your knowledge was of, the employer's requirements and indeed the guidance documentation, some of which was said to be compulsory and some of which was said to be considered rather than necessarily followed. And you say you were familiar with that, but in the middle of paragraph 36, the technical content and application was beyond your remit and understanding. So does that mean, say, we'll take the one that we're always talking about, which is SHTM 0301 hospital ventilation. You were aware it was in the list and aware perhaps generally of the kind of things it dealt with,
Yeah.
but the detailed content wasn't something you were on top of.
No, because that's a mechanical engineering document about ventilation, which, to be fully understand, you would need to be an engineer.
What about another document that we've heard about, clinical output specifications? Did you have any involvement in these?
Very limited.
Very limited.
Yes. They were primarily done by Heather and Mary along with the user groups.
Right.
Sorry, Mr. Hall.
Sorry, they were done by Heather Griffin and Mary McLeod along with the user groups, typically.
And then in paragraph 39 on page 207, I come to it because it's obviously a point you're very keen to ensure we noted, that while the exemplar design was important, it was never built as such. So it's not a question of somebody saying, well, here it is, just go on and build it.
No.
That's not the way it worked.
No, you could, I mean, as I say, it was only a sample of departments. It didn't consider how those departments, married up with the rest of the hospital or anything. So you would never have been able to build what was in the exemplar element.
And I think probably Emma White told us about this. What was done, as you illustrate in the same paragraph, is the 11 that had been dealt with were redone.
Oh, yes.
As part of the overall design. It wasn't a question of saying, fine, we've got 11
Yeah.
filed away, let's do the others.
Yeah.
Is that right?
Yes, that's correct. And that in itself presented some challenges because in some instances there had to be compromises. So there were some debates about, well, actually, some of the consultants would have said that they preferred the exemplar, but it didn't work into the overall building.
My lord, I'm, in terms of the witness statement, going to move on to a slightly different topic now, if this is an appropriate time to take our break.
As I said, Mr. Hall, we usually take a coffee break at about 11:30. So could I ask you to be back for 10 to 12?
No problem.
Thank
That's
you.
fine. Thank you.
Please stand.
Mr. Connell.
Rise, my lord. Just before we move on to the next section of your witness statement, I've got one or two slightly random appearing questions because that's the nature of this beast. As soon as we stop talking, we suddenly think of something else, or somebody else thinks of something else. First question, and you may not know the answer to this. Do you recall when Curry and Brown last billed GGC for Wallace Whittle's assistance?
And no, I wouldn't have been involved in that, sorry.
Another one that perhaps I should have asked you at the time, you described in the course of trying to explain how some of the discussions with clinicians about what they wanted proceeded, that one had said to you, oh, the SHTMs are balderdash. With depressing inevitability, somebody has said, well, you better find out who that was. Do you remember?
I would prefer not to say. I'll be honest. I think that was something that was probably said in, in a light-hearted mode. I think that would be unfair on an individual to name them.
Sorry, could you just repeat the question?
The witness, my lord, explained earlier in an endeavour to illustrate some of the issues that arose where clinicians wanted X and they were being told they can't get it because of the regulations or the guidance, which pointed in a different direction, that the witness recalled one clinician referring to SHTMs as balderdash. At least one of the CPs is interested in knowing the answer to that question.
I have to say, I don't regard that remark as so discreditable, or indeed as discreditable at all.
Well, in that case, perhaps I would ask the witness, given what his lordship had just said about the remark and what you've already said about the circumstances in which it was made, if you would tell us who it was.
It was Carol Davis.
Carol or Carol?
Carol.
Carol. Thank you very much. And again,
I suspect harsher things have been said about SHTMs.
It just probably a question which impacts on our understanding of processes. When we were going through what Wallace Whittle had or hadn't done and where they might or might not have appeared post January 2010, you were explaining that there were these sort of review meetings while things were being put together to go into a final version before the full business case had to be done. And you said there was a bigger one and then a sort of final version. You also mentioned there were discussions about possible conflicts or inconsistencies between different pieces of the guidance or employer's requirements. You remember telling us about
Yes.
that? And am I right in understanding that if you like, the agenda for these discussions was purely driven by what Multiplex had identified as such issues rather than, say, the board had done?
Yes, because that was their responsibility.
So it's not that the board is going around checking things and saying, we have a problem. It's Multiplex are saying, when you look at this, there's this issue.
Yeah, it was Multiplex's responsibility to deliver the hospital in accordance with the employer's requirements. Where they identified there was a conflict, then it was their responsibility to raise that and seek agreement to the alternative design solution that would overcome the conflict.
Was there a particular forum for that, or process for that, or was it ad hoc?
Well, I think in that period of design, the process for mechanical, electrical and plumbing installations, the process was those review meetings that Wallace Whittle attended because there was no other forum where there was a specialist on the board side to do that.
Right. I probably should know where this fits in. There were specific design review meetings.
Yes, that was the August and the October.
Right.
of
Are these,
2010.
right. Are these the occasions of the presentations that you described?
Yes.
Right. Okay. So it wasn't a regular course of meetings, but right. I've got it. Thank you.
Well, I'm now going to move back to your witness statement. We'd reached page 207 of the bundle. And I'm now coming back to things that might be laid at the door of a project manager. Now, whether that's Mr. Moyer or you or both, we'll see how, as we go forward, because we're going to go to the issue of the removal, what's been described. And I'm afraid sometimes the inquiry has put labels on things that you may not think are accurate, in which case you can tell us, but it's been described as a removal of the maximum temperature variant. And you say, well, you had no technical involvement in this because it's not your area of specialism, but you were aware of it through your project management role.
Yeah.
Now, I suppose that the question I wanted to ask about it was this. If you change a particular parameter to which everything else then has to fit, would it not be obvious to a project manager that could have knock-on effects on other issues? So if you change the temperature, could it affect whether ventilation, IPC? I don't know.
That would be reasonable. Yeah.
And in your project management involvement, would it not have been part of the role of those project managers who were aware of this to point out to Mr. McIntyre, whoever was driving it, that this could have other consequences and therefore these needed to be explored first?
I think this is the point at which potentially I need to just clarify that the point as to when the decision was made and also enacted. So there was a request came in from Alec McIntyre based upon the experiences again from the ACAD hospitals about overheating. So I would have referred to this as an alteration of the maximum temperature variant. But yeah, and I take the point. Yeah. So he requested that the project look at this. So the project looked at this both prior to entering into the initial contract with Multiplex to design the hospital. So we looked at it in December 2009. What we agreed to do at that point was effectively to make once we got the two parties, ZBP, Wallace Whittle, into a place where they thought that it was reasonably likely that we could achieve an acceptable outcome, that was inserted into the contract for the design. So the decision wasn't made at that point. All you were doing was putting a line in the sand that said Multiplex's liability was to design the building to those parameters. That parameter could be changed at any point from 2009 through to 2010, whilst the consultations were done with infection control, done with people external to the board, Peter Hoffman and the likes through. So the decision in 2009 was to agree that this was a reasonably likely option and that it could be built into the design contract so as to be fully developed when the design of the hospital was developed. Only in 2010 was it then effectively enacted. So, as I say, the decision in 2009 was to consider whether it was likely to be achievable in an acceptable manner. And to my mind, Wallace Whittle and ZBP agreed that based upon precedents in other hospitals and things that had gone before, there was a reasonable likelihood that an acceptable outcome could be achieved. And therefore, that was the baseline that was set for what was in the contract. The piece about how it was then designed and developed and approved happened in the following year. The decision wasn't effectively made in 2009, it was made in 2010. Because that's when the design was completed.
But am I not right in thinking, I'm jumping ahead a little bit, that the reduced maximum temperature just for simplicity, let's not worry about the hours for the moment, 28 to 26, actually played a significant role in driving what we've come to hear about as the ventilation derogation,
Yes.
which was agreed
yeah.
in the contract.
That's correct. But what all I'm saying is that there was an opportunity. So the decision in 2009 was to accept that into the terms of the contract. If during the following 12 months there had been an issue with that and it hadn't been taken forward, there could have been a variation to the contract to do something else.
Yeah, I'll come back to this, I think, when we come to the
Okay.
ventilation derogation, because at the moment I'm struggling a little to understand how you can have a conversation about the ventilation derogation, the gist of which is, well, now that you've got this lower temperature to work with, we have to cut the air change rates. Here's a way of doing it. And then say, well, don't worry about it. We can do something different later.
No, I'm not saying that. What I'm saying is that the finality of the decision was not until 2010, because that's when the design was concluded for all the systems. What happened in 2009 was that it was agreed at that point that there was a reasonable prospect that a solution could be found based on that, and therefore the terms and cost of the contract, there was a target price and also what was in the contract for the design. Because Multiplex wouldn't accept going forward without some line in the sand, right? So we had to put a line in the sand which said that's what you've based your price upon. And there was a reasonable assumption between ZBP and Wallace Whittle that the solution that was put forward at that time could be made to work. If, as the design developed, that was proven not to be able to work, then it could have been varied at that point.
So, and just so that I was sharing Mr. Connell's, I think, failure to follow, but can I explore this a little? When you talk about a line in the sand, you mean, if I understand you, that Brookfield were being asked to price on the assumption that they had to achieve 26 degrees.
Correct.
Right.
And that the way they would do that was with the reduced air changes. So that was the pricing assumption. So it gave them a line in the sand. If it was then proven not to work or to be something else, that would instigate a compensation event under the contract, which would then be assessed. That could either be positive or negative in value.
Right. I think I have it, but I think what Mr. Connell was concerned to explore or confirm was that the decision on the maximum temperature was a reason, or perhaps the reason, for what we're describing as the agreed ventilation derogation. And I think I understand if Brookfield are being required to price on the assumption that it's 26 degrees, I think I follow why the temperature leads into the decision on the ventilation derogation.
It's certainly a reason, yes.
Right. Do you feel I've got the point, Mr. Connell?
Well, that's I wouldn't speculate on whether my Lord has the point or not, but my Lord can be assured it will emerge again in the not too distant future, so that hopefully we can all be clear what the point is, because at the moment I'm struggling a little with the contractual sequencing here. Although, as Mr. Hall has pointed out, it may be that what we're being told is that the contract was then locked in, and that meant that any change from that required a compensation event. And as Mr. Hall technically points out, a compensation event doesn't necessarily mean the paying of more money, but might.
Yeah.
I suppose that the reason I'm asking about it, Mr. Hall, is that one of the things we've had drummed into us by other witnesses is that you need to sort the ventilation early because it impacts on so many of the construction
Oh yeah,
elements.
And the point I'm making is that there was 12 months to do that sort, if you know, because actually the instruction to proceed was not until December 2010. So there was further consultation through the period of 2009 into 2010 on this subject.
Consultation with who?
I've referenced Peter Hoffman, for example, in my witness statement.
Yeah, but that was in 2009 when the discussion was taking place.
I think there was further discussion as well, is my understanding.
Again, one of the reasons we're asking all these questions, Mr. Hall, is that the existence of the ventilation derogation appeared from the evidence the inquiry has had to be largely unknown, out with possibly one or two people in the project team, many of who were not by then present in 2015 when the hospital opened. So we have a slight issue here to understand how everything actually happened. So if I'm asking you questions that don't make sense from your understanding of what happened, please just tell us. The next topic it touched on in your witness statement is chilled beams, and basically you said you've no technical knowledge about these at all. Were you, chilled beams, as we'll see shortly, played a part in the proposed solution that you mentioned that led to the changed air rate derogation. Were you aware that one of the other bidders had pointed this out to the board during feedback on the bidding process and said you won't get your air changes if you use these chilled beams?
I've seen that document subsequently, but at the time I wasn't aware of that.
Who do you know who would have been aware of the bidder feedback?
The bit of feedback, I presume, would have gone to Peter Moyer.
All right. So somebody would have known that it was being pointed out at that stage. You know, it's going to give you an issue with air changes if you go down that road.
Mm-hmm.
I'm asking that because I think what you go on to say on page 209 is that the people responsible for making sure that the requisite SHTMs, air pressure differentials, all that stuff goes into the employer's requirements were actually, ironically, Wallace Whittle working for you. That was part of their role.
What, to insert those into the...
Yeah, to make sure they were there.
Yes.
Yeah. Now, on page 209, and I'm not going to ask you about the particular question, I'm going to ask you about a definitional point. You asked who is responsible for high scribe, and you say the board was responsible. Now, you use the phrase "the board" quite a lot in your witness statement. It was the board to do this, the board should do that, the board were told this. Am I right in understanding that when you use these phrases in relation to the work you were involved in, you actually mean Peter Moore or Alan Seaborn?
Not always. I mean, many of these things, as I understand it, were taken to sort of project board meetings, which included the likes of Helen Byrne and Robert Calderwood and others. So when I refer to the board, that could include up to that level as well. I didn't necessarily see sight of what was all escalated, but I was aware that certain issues were escalated beyond the direct project team into the structure of the board.
Well, we'll come to that particularly in the context of the ventilation derogation, because there's mention of the board repeatedly at that stage, and we'll need to understand at that point exactly who you mean when you make the statements in your witness statement. The next point that you were taken to, or were taking us to, was what were called technical review group meetings. And in fact, I won't bother putting up these minutes because you've explained your position. Your role was simply to make sure that all the documents were there and these got organised. Is that right?
Yes, correct.
And then you say on page 210, compliance with SHTMs and ATMs was extremely important, and you describe it as a fundamental requirement of the employer's requirements. Now that's an interesting statement, of course, because when we come to the ventilation derogation, we know that there was a departure from what was said to be a fundamental part of the employer's requirements, which had been put together by, among others, Wallace Whittle. Is that right?
That's correct.
Yeah. And you say you believe it was a term of the contract that they should be complied with. Now, I'd like to take advantage of your experience here. What we've been looking at is a situation in which an enormous amount of effort has gone into creating the employer's requirements and everything that goes with that. List of guidance, visual indications, meetings with user groups, a big pile of effort has gone into creating something called the employer's requirements. Do you think, from your experience, it was understood by the key players in GGC, presumably the project team, and those who were talking to the project team, that any of these requirements could be dumped and as a result of the discussions which led prior to the contract being signed by simply being removed?
I think dumped isn't, not the
Well-
right word.
Well, removed.
Yeah. Well, as I say, to have a derogation or an alternative design solution is not an abnormal circumstance. I think any development of the scale that this is, will come up against conflicts in terms of what is within the whole suite of documentation. And only when you design the building through can you understand what all of those issues might be.
Well,
So-
I can understand that point. What I'm trying to get at is whether you have any view on how well it was understood by the key board people that potentially, they could have spent
Yeah.
a very long time working on a particular requirement, but in a discussion involving only the project team, that could be disapplied.
I don't believe that the discussion was only within the project team. My understanding is that, and others will be able to confirm this because they were literally would have had those activities, those conversations. But my understanding is that the conversations extended beyond the project team, into infection control and into management.
As a matter of, you've set this out somewhere, I'll find it when we get there. As a matter of contract arrangement, a departure from employer's requirements could be authorised by Peter Moyer as the NEC project manager, is that right?
Contractually, yes.
Yeah. Do you think that was understood widely by those who are working on producing the employer's requirements?
On producing the employer's requirements?
Yes. Well, we've talked about what I might describe as a big team effort to create these employer's requirements, lots of input from different people from GGC. Did they understand that the way the contract was set up, the project manager could derogate from these?
I would have thought that would be the case. I mean, anybody with a basic understanding of NEC contract knows that the communication to alter the contract comes from the project manager.
And how widely do you think, from your knowledge of the people you worked with, was there an understanding of the NEC3 contract?
If Douglas Ross was here, we could have checked with him, so apologies, but I'm going from memory here. I believe that an NEC briefing was given to the project team by Douglas.
Now, you can see where we're going with these discussions, because it's the next question you're asked on page 210 is, well, whose job was it to make sure that these fundamental requirements got not only put in the employer's requirements, but got kept in place? And your answer to that is, well, everybody in the project team. And does that include Curry and Brown?
Well, in the sense that I was providing project management support to Peter, yes.
The next topic you've asked about is BREEAM. Now, I'm not going to delay us on BREEAM, because your answer is on BREEAM is that you don't think it was given more importance than SHTM compliance, and that's not something you would expect to happen. That's on page 211 of your witness statement at the foot of paragraph 53. And it so happens that general approach coincides with a number of witnesses who've been asked the same question. So I don't need to ask you anything further about that. And you're not really able to help us with the 80 kilograms of carbon target, because that's out with your expertise, but maybe within the expertise of others we'll hear from. So that then brings us to the competitive dialogue process, and essentially what you say there is your job was to make sure all the sessions happened and were administered properly, and you didn't show one bidder what the other one was saying, and practicalities of that kind. That was the role that you understood you had.
That's correct.
Now, the next topic that you cover is the selection of a sealed building design. Now, we've seen lots of communications about whether you can have sealed buildings, partially sealed buildings, buildings with some of the rooms naturally ventilated or not. And the design in that sense is not a matter that you're here to tell us about, but you were clearly aware that there were discussions about this.
Yes.
You say something I wanted to ask you about in paragraph 58. You say you were aware of these discussions, but it was Alan Seaborn's responsibility to obtain approval for that decision. Now, where would he go to get that approval, from your understanding?
I would have thought he would have gone to the senior management level of the board, and directly in that line at that time was Helen Byrne.
So that you think at least that would be something he would need to go to her and seek approval for.
Well, I think it would be something he would make them aware of.
Right. Well, I'm just using approval because approval is the word that you used in your witness statement. Is it then more a question of it's something he should tell her about?
Yeah, I would have suggested so, yes.
And he would just make the decision
But
himself?
the decision is based upon advice of the experts. So he would be communicating the advice of the experts.
And you're at the top of 213, you're asked, so far as you can recollect, what the rationale for a completely sealable building was. And that was to minimize risk of infection, as well as reducing odor nuisance. We'll come back to odor when we touch on carbon filters. Then you take us further through the chronology by dealing with the bid evaluation, and you explain who was participating in it. Now, you say representatives from the technical team. That's your group of sub-consultants.
Yes, that's correct.
Discussed. And then Alan Seaborn, Peter Moore, Francis Rath, and Mary McLeod. Did they have expertise that was relevant to assessing bids?
In terms of the clinical functionality element, I would suggest yes.
Thank you. Then you're asked again at the foot of that page, probably the same question you've been asked earlier and answered, that was SHTM compliance important during this process? And you say yes, it was, but other things might crop up that cut across it, but patient safety and comfort were of paramount importance.
Yes.
That's your recollection of that
Yes,
process.
correct.
And then there were presentations. Now, we now come to the topic of what the inquiry has called the ventilation derogation. So if you just allow me to use that label for the moment. The two initial questions I wanted to ask you, and one of them harks back to the point that we had a little bit of understanding difficulty earlier. The impression that a reader of the exchanges may get is that there were the only choices available to the board at that time were either to say, yes, we're prepared to agree this, or no, we're just not prepared to agree that at all. There weren't other options on the table. Can you remember?
This is the point I was trying to be clear about. This was an option about what should be included in the target price. The design was still to be developed. In 2009, there was no full hospital design. There was a period of 12 months to fully develop all of the systems going through. So in order to get to the point where we have agreement on what is contained within the target price in 2009, we have to put something in against this. What is reasonable to put in against that was the discussion between ZBP and Wallace Whittle, who then advised the board on the preferred option to have as the line in the sand. The following period then develops the design of the solution, and there are further discussions around the subject in the following year before it gets to instruction to proceed, at which point it is committed to.
You could take various views about the significance of the decision that was made. We've had a view expressed that it was a matter of sensible detail. Another view might be that building hundreds and hundreds of rooms in a flagship hospital at less than half the air change rate recommended by guidance was at least potentially quite a significant step. Where in the process 2010 do you recollect any discussion of whether that should or should not happen?
That would have been in some of those workshops, for example, reiterating that issue, because that obviously continued to fall out with the exact requirements of the employer's requirements. I also believe that there were other discussions with other members within the board in terms of going to infection control and going elsewhere to discuss this matter.
Do you know who in infection control?
I believe it was Craig Williams.
So by that time, the contract was structured that if someone had persuaded the board to say, whoa, we can't do this. We cannot go to Scottish Government, for instance, and say we're about to build a hospital that doesn't comply with your guidance in this respect. Or we might not convince them, or whatever the point was. That would have then led to a compensation event if a different option.
Correct.
And would have presumably led to a complete revisiting of the consequences of that in terms of the entire ventilation structure.
Correct.
Because we've heard from other witnesses that the number of air change rates influences ceiling voids, size of air handling units, size of ducts, and everything else that would then have to feed into the construction process. Now, the other thing I wanted to ask you about this process before we look at some of the details is that we know it's in the log, and I'm going to have a discussion with you about the use of the log for that purpose later. But there are obviously meetings and other discussions have taken place in a relatively short space of time about this topic. And we don't seem to have any, apart from the emails introducing the existence of the meeting, we don't seem to have any records of any of these meetings from anyone. Now, would that not have been a project management responsibility for Curry and Brown, either in the shape of yourself or Mr. Baird, who was also involved?
What period are we talking about here? Sorry.
The exchanges in December 2009, which led to the ultimate agreement of the ventilation derogation just before contract signature.
The type of meetings we're talking about, the log was the record of the meetings. The actions would be about the log, and the log would then follow that.
Well, the log doesn't, I mean, it tells you something, but it doesn't tell you, who said what at the meeting in the project room or anything of that kind. Should we not have notes of these of some kind, minutes?
These meetings were, rapid, and the log was the agreed tracker of those meetings.
Mm-hmm.
Are you envisaging, as it were, internal meetings as opposed to
Well,
Brookfield
yes,
GDC meetings?
I'll take this witness to each of the communications, but one of the challenges that the inquiry has had is that we know there were meetings. There are notes saying there were meetings. Many witnesses can't remember what was or was not said exactly at these meetings, or don't even remember in some cases whether they were there. So we don't have any record of the exchanges on this matter, which then led to final agreed position. Now, is that not a fair project management point to make to you?
Formal meetings would be minuted, but these were ad hoc meetings which were held to resolve issues which were covered by the log. Not necessarily all with Curry and Brown present.
Well, would that not be a project management issue for you to know what was said by whom?
As I said, the project management was a team with activities going on. It wasn't just one person.
Well, right. Curry and Brown were assisting on the project management. Would it not have been part of Curry and Brown's role to make sure that records were kept on this important matter of all the discussions?
As I say, the actions were caught on the log. That was the tool that was used.
Well, let me just ask you about the log. This is described as an M&E clarification log. Now, in the course of other evidence, it's suggested if you're going to make a derogation of this scale affecting hundreds and hundreds of rooms, the correct place to record it is not in something called an M&E clarifications log, which contains any number of detailed points on a whole range of issues. It ought to be brought out in something rather more formal and separate, perhaps a derogations log or a major derogations log. Now, do you have any view on that?
The logs were part of the contract. So as far as I'm concerned, in a normal construction contract, the logs are the normal place you go to find the variances. The body of the contract, effectively, in most cases, is normally a standard contract with X7 and X12 and all those sort of things appended to it. If you're looking for the exceptions, you look in the logs. That's normal.
Well, if you were, you know that because you've been in the construction industry all your life, but in order to find the derogation, you would need to know that something of that type, first of all, would be in something called an M&E clarification log, and then you would need to go to the M&E clarification log and work your way through it until you eventually found it. Is that not asking too much from anyone who's not had a lifetime in construction?
I'm not sure who you're meaning in terms of who's looking for it, though.
Well, somebody needs to be able to find it, and part of the issue that the inquiry has had is it's being told nobody knew about this. The hospital was opened and people weren't aware of it because it wasn't overtly present in any readily found document. You could find it, no doubt, if you went to the contract and you worked your way through the contract priority list and you discovered the M&E clarification log had priority, then you went, well, that's where I'll find a derogation, won't I? And go and look at it and work your way through all the paragraphs in it. I think a question has been raised, and I'm just asking for your view as to whether M&E clarifications is even a correct description of what was done here.
I mean, in terms of that communication, I think you would have to refer that to Alan Seaborn. I mean, Alan Seaborn was fully aware of this, and obviously, you know, he was the main conduit into the board.
Yeah. Well, do you accept there's at least a question as to whether a change of this scale for this project should have been in something called an M&E clarification log?
It's in the correct place in terms of the contract, but whether it should have been somewhere else in terms of visibility within the wider board is a different question.
Part of my, so I can put a context to that question. Part of my reason for asking that is that the employer's requirements, which refer to compliance with SHTM 0301, among other things, remain in the contract bundles, as it were, unaltered, unamended, without any indication that there has been a departure from them.
Yeah.
So if you went to the employer's requirements, you would see compliance with SHTM 0301. You wouldn't see except when air changes are meant for your general rooms.
Because the clarification log is the place where the changes to the contract or where the exceptions occur and are recorded.
So in the context of the ventilation derogation, I've asked you about your project management role, so I won't ask you that again, but you're using Wallace Whittle as technical advisors on the job. And you're asked, page 215, was it part of your role to ensure the importance of SHTM was stressed and to ensure there was a process to inform the board of any significant departure from SHTM? Now, by that, I do not mean Alan Seaborn. Was it part of your role to make sure that, you know, the wider board structure were aware that something of this kind was going on?
No.
Why not?
Because I reported into Peter Moyer and Alan Seaborn. You know, I wouldn't have seen it as my responsibility to go to senior members of the NHS management and inform them.
I need to ask, part of the reason I'm asking you that is that it may be, from what I've seen so far, that Mr. Seaborn will say that it was your project management job to make sure that that went wherever it needed to go within the board structure. Do you agree with that?
No, my duties were delegated by Peter Moyer, so I reported into Peter Moyer.
Now, in the same paragraph, you're asked about the importance of SHTM, and we've covered the admitted importance of SHTM, and you say that was stressed by you and by members of the technical team, including in the employer's requirements. Okay, so we've passed that now. And during discussions about any proposed departures from SHTM. Now, when you say that, do you mean during this discussions over this ventilation derogation, or is that just a general comment?
It's a general comment.
Do you remember you or Mr. Baird, for instance, because I know he also participated in this process, stressing during these discussions the importance of compliance with SHTM?
Well, that's why the derogation, you know, why those discussions were happening, because there was like a competing requirements that required a review and coming up with an alternative design solution.
Well, that's not quite the question I asked you. We know there were various exchanges around this before a final decision was taken. Do you remember whether Curry and Brown stressed in these discussions the importance of compliance with SHTM?
If this is the December 2009 meeting, I don't believe I was personally in that meeting, so I don't think I can comment. My memory does not have me in that meeting.
are you aware whether anyone from Curry and Brown stressed that?
I would suggest you did ask Mark Baird.
We'll see Mr. Baird next week, so I'm obliged for that. And then you say the logs were understood by the board and by all in the project to be the correct channel for communications on such issues. Now, I can understand Mr. Moyer might understand what was going on and Mr. Seaborn, because for the reasons you've explained, they were directly involved in how things were done and how things were recorded. Is that what you mean by the board at that time? The project team?
I would take it wider than that. By the word, that is the project team at that point, but I would take it wider than just those two individuals. And these things were discussed at regular review meeting, progress meetings with the wider team, with others in the room.
One of the issues we have, and this bit is nothing to do with you directly, Mr. Hall, but I need to ask you about it, is that the board has, and by that I mean the board as a corporate body, has searched for records or communications of this decision being recorded as discussed at any of the many committees, bodies, and other such exercises, and has not, according to Mr. Steele, who gave evidence here in the last sessions, found any such record of any such discussion at any such body. Can you help us at all as to why that has happened?
I would simply say that I think you have to ask Mr. Seaborn.
And the tail piece, I just want to ask you the tail piece of paragraph 68, post-award of building contract. So this is after this is agreed, and then I was about to use the word locked in, but you tell me it wasn't. Put into the contract. You say responsibility for informing the board of any significant departure, and I assume that's from SHTM,
Yeah.
lay with Multiplex.
Correct.
Where would we find that responsibility laid? Because there's no indication that, well, there is no record, I don't think, anywhere of Multiplex going to anyone out with the project team and saying, we are obliged to tell you that this derogation.
It's to advise the project team that it's a derogation. So they have to highlight it to Peter Moyer as the project manager, that they are unable or proposing not to comply with something that is in the employer's requirements.
But that's what they've just done in the discussions which have led to the derogation being agreed, is it not?
But for this instance, yes.
Yeah.
But also that then occurred later on as well in other areas and issues when there was other issues that had to be discussed.
Well, just let's stick to this one or we'll get confused.
Okay.
Multiplex advisors have said, for this reason or that, we just can't make it work. Therefore, here's a solution, and there's a discussion about it, and then there's an agreement on it. That's putting it without asking you to look at any of the documents. After that's then put into the contract, which is then signed a matter of days after some of these exchanges took place, does this comment from you anticipate Multiplex doing something to take that further?
They
Because
didn't have
Mr. Moyer already knows.
No, they didn't have a design at that point, right? So in terms of the systems, and they then had to develop that design through the following year.
Can I ask you about some of the details of the exchanges insofar as you can assist us? Right? Bearing in mind your general statement that you were not the designer and you're not an M&E expert.
Sorry, just want to make sure that I've understood Mr. Hall's answer. You said, Mr. Hall, that as at date of the contract, and therefore as at the date when the ventilation derogation had been agreed, you said they didn't have a design then and had to develop it during the following year.
Yeah,
Now,
they had a design strategy.
As a statement, I understand that to be correct, but I'm not quite sure that if I've understood the significance of your answer.
Well, what they had at that point would be a design strategy, and the strategy would include at that point this method of servicing those rooms, i.e., with the chill beams, but it's not a fully detailed design. They have to, they haven't sized anything. They haven't looked at air handling unit plan, air handling size. They haven't looked at pipe size, anything like that. So they have a complete design to undertake in the following 12 months to develop what was effectively a strategy point into a full detailed design.
And therefore, I
As that-
understand the point.
so-
I just wondered if there was a significance
So-
in your answer that I was missing.
No, and that then results in those workshops throughout that period in August and October to review how the design has developed. So, they had a strategy in December. They then worked up their design through to August. They presented that design back to Wallace Whittle, who came in that almost like a gateway review type review on that. They went away, tweaked that again, and then came back in October. And then it was only in the December of 2010 that the instruction to proceed went ahead to go on the basis of that design.
Right. Just to make sure that I'm following, what I'm taking from that so far is there in the workshops or presentations in August and September, August into October 2010, there would have been an opportunity to revisit the level of air change.
Certainly to discuss it, yes. And
that's the point you're making.
Yes.
Leaving aside the contractual consequences of doing that.
Yes.
Right. Thank you.
Now, we're now going to move into the documents such as they are that we have about the ventilation derogation. One of the features that emerges from a lot of these is many of them were taking place within a matter of days of contract signature. Is that a slightly odd point to be doing something as big as changing the air change rates of most of the hospital? You've only got a couple of days till
Again,
pen has to go on the paper.
It's about a strategy. It's not abnormal that certain things go to the wire in a contract negotiation. That's not unusual. So, is it abnormal? No. And as I said before, it wasn't as if at that point it was an absolutely final decision, because there was the opportunity to revisit thereafter. So it was about putting the line in the sand rather than in fixing the design, because we didn't have a design at that point.
I probably won't bother putting it up on the screen, but I will if you need it. In the course of these exchanges, and you're asked about it in your witness statement at paragraph 70 on page 216, one of the comments that emerges, and it actually emerges in a slightly odd place. It emerges under Brookfield comments, but it's attributed to John Bushfield, who is not Brookfield, but works with Wallace Whittle. And in fact, we have a statement from Mr. Bushfield who says, well, I don't know who it was, but it wasn't me. Anyway, that at the time, there's a statement attributed to Mr. Bushfield which says, derogation not accepted, and then any variation would require board clinical infection control review. Now we're in December, so we're heading towards contract close. As the project management people who are assisting in this process, did you do anything to make sure that, first of all, there was such a review, and secondly, there was time for such a review?
I think the point I was trying to make earlier is that there was subsequently time for review. I wasn't personally involved in this, as I said. Mark Baird was more involved in it. But my understanding is that the agreement was reached between Wallace Whittle and ZBP. I am not aware of what other conversations went on around that, but there was time thereafter to review that with infection control. based
The
on,
Bushfield comment said, somebody's saying we want to do something different, which involves a derogation, and Mr. Bushfield apparently, or at least attributed to him, says not accepted. This needs IPC review, and I'm just trying to find out if you're aware of anything being done at that time before it was accepted.
not that I'm aware of.
Because when you're asked about it, again, in effect, in paragraph 72, you say, my recollection is that following the comments by John Bushfield, a report was produced by Wallace Whittle discussing compliance with CIBSE design standards, which doesn't really meet the point, does it? That's a report on a different topic. It's nothing to do with IPC review. I just wondered why you'd explained it in that way.
Well, I understood that there was a further discussion with Wallace Whittle, and there was reference to the SIBSE report, SIBSE standards, and that was part of the agreement as to why it was a reasonable way to move forward.
Well, that bit I understand. I'm just wondering why you were linking Mr. Bushfield's point, we need IPC sign off on this, with a report on whether it complies with CIBSE standards.
Because Mr. Bushfield worked for Wallace Whittle, the report that came from Wallace Whittle, my understanding was that responded, to the points. And the point about in terms of infection control, appreciating all the timescales, time of year, and everything else is the point I'm trying to make is that there was an ability to amend that if there was a major issue at a later date.
I think you suggest there was some discussion with IPC at the time, or at least you have a recollection of hearing that there was. First of all, are you aware of any record of any such IPC review?
As I've said before, I haven't had access to records for 10 years, so apologies. I can't comment on that in terms of what might sit there. It's very difficult to remember exact dates, timings, sequences on all of these things. What I do know is that there was conversations at a point in time with infection control, with the infection control nurse, with the wider project team, including people like Fiona McCluskey and Heather Griffin was, I think, involved in that as well, and probably Francis, in terms of the fact that the single bedrooms had a different ventilation arrangement. This is not something that wasn't discussed. Now, what I can't categorically say was whether that was around this time or was later in 2010 in the period when we were actually developing the design.
Sorry, could I just have that again? As I say, quite quickly.
Sorry,
quite quickly.
Apologies.
Could I just have that answer again?
Right. So it's difficult in terms of memory to remember exactly what discussions occurred at what point in the sequence. However, in the period from December 2009 through to the point where we were instructing, I am aware that there were conversations with infection control, both in terms of going to Craig Williams and also in terms of the nurse, the infection control nurse on the team, which did change around that time because there was Annette Rankin initially, and that then changed to Jackie Stewart, and there was a gap in that period as well, in terms of one to the other. I can't remember the exact timing of that, but there was involvement there, and with Fiona McCluskey, and given that the predominant discussion about these single rooms was about the ward stack, with Heather Griffin as well.
Yeah, just so His Lordship understands your last point, that is that the discussion at that time had focused around the adult general wards.
Yes.
That's just where it had come from.
Yes.
Yeah. And in fact, you go on to say, well, let me just put this to you. Would it be fair to say that it's unlikely that any of the IPC nurses would regard themselves as either qualified or willing to sign off on building hundreds of rooms without compliance with standards, that wouldn't be up to them, would it?
I wouldn't have thought so, no.
No.
But they should be aware.
Can you help us at all as to where we are likely to find if we look? Because we haven't found so far any confirmation from any IPC individual confirming agreement to this strategy.
Well, the communication with IPC at Craig Williams level was from Peter Moyer and Alan Seaborn.
And you also say, and I need to make sure I take this from you, that your understanding from Mr. Seaborn was that in addition, at that time, he'd spoken to Peter Hoffman about it.
Yes.
Is that correct? We asked Mr. Hoffman about that when he was here, and he had no recollection of anything in 2009.
Oh, no, sorry. No, sorry. That's the point. My recollection is that was in 2010.
Or 2010?
Yes. And that's why I was emphasising this piece about when the decision was made, there was still time to amend that. Were there any issues?
I mean, I can understand, we understand that from time to time, Mr. Hoffman, might show what's happening behind us, will blame some construction company, probably.
I'm used to it.
We had from Mr. Hoffman to the general effect that one of his functions, it's probably putting it too highly, but his roles was that people rang him up from time to time and said, yeah, what do you think of this, or what do you think of that? We haven't found anything in writing from Mr. Hoffman on the ventilation derogation as such. Nor have we found anything in writing asking him for advice on whether that should be agreed or not. Do you know what the content was of any discussion between Mr. Seaborn and Mr. Hoffman? If you don't, just tell me.
I don't have the specifics.
No, the part of the material that was circulating at the time was something called a ZBP ventilation strategy paper. Now, you're asked about that on page 218, and you think you must have become aware of it sometime around the date it was produced, so 15th December. Now, is your answer going to be the same to the question I have then? That here is a document coming from a specialist, a matter of 3 days before the contract was signed on the 18th. It doesn't, on the face of it, give much opportunity for debate, discussion, analysis, or anything else. Is that a fair point?
Yes, but again, I reiterate the point that there is still the flexibility in the following year to address that. So the question to Wallace Whittle and at that point is this a reasonable way to go forward? I.e., does it give us a line in the sand for the target price?
And in fact, your evidence is that you probably, thinking back, you probably knew about it at the time, but you don't recollect doing anything with it or being involved in any discussions about it.
No, as I say, I think probably better, in terms of that conversation, Mark is probably better placed to answer that.
And just so we can put the context around that, if we go to paragraph 81, you referred to an email exchange between Mark Baird and Stuart McKechnie of Wallace Whittle. So I think we should put that up. Bundle 17, page 2861. And there were various things said on this. Am I understanding your evidence to be that you were copied in, but you weren't primarily involved in these exchanges?
Correct.
And can you help us at all when it says WW to take board through this, who board would mean?
That would be Alan Seaborn, Peter Moyer, and others within the board team.
Right. And I think there's another one at 2869 we probably better just put up in fairness to you. I think your answer is probably the same, that you're copied in, but you think that was about the extent of your involvement. You were aware of it happening, but not directly concerned.
Yeah, I mean, as I say, a lot of these things, it's about covering for each other. It's about team. I mean, you're copied in, so as if something occurs. I actually suspect on the 15th of December I was possibly on holiday. It is my birthday, so it may actually have been a day I wasn't even in the office, but it would only have been the day.
So, and because that's another email which appears to infer there was then a meeting. And one of the challenges the inquiry has is that we don't have any record of that meeting. We think it probably happened because there was a meeting room booked or something, but that's all we know.
Right.
Can you help us at all?
No, sorry.
One of the topics that then raised about this whole issue is whether, given what was being suggested, someone should have been doing a risk assessment to look at all the possible consequences and issues in a sense of something formal, rather than just phone somebody up and ask them what they think, or have a half-hour meeting that there's no record of. Now, your answer when you asked about that is that Curry and Brown had no responsibility for risk assessments and you were never asked to produce one. If there had been one at the time, either requested or produced, would you know?
Possibly.
And who would have been responsible for risk assessing this proposal?
Well, I think
Suggested way forward. So,
I think in my answer I said I thought it would be something that infection control would have led on.
So if somebody wanted to assess the risks that might arise, or might not, who knows, until you do the assessment, arising from this proposed solution, you would expect that to be done by IPC. Were you aware of any such assessment being done by IPC?
No.
Were you aware of anyone, to your knowledge, suggesting that that was something that needed done?
No.
Let me just finish this. Get a little step towards finishing this particular part of the exercise. The picture you're suggesting to us is that there were some exchanges, a decision was reached, and it was then incorporated into the contract, as we know, in the way that we've discussed, for good or for ill. But that there would have been an opportunity to change direction in the next year, had that been desired.
Yes.
Are you aware of any change of direction ever having been suggested or discussed?
No.
Because the alternative view might be, and I'd like your comment on this, that once you've had your discussions, you've been to Wallace Whittle, you've bounced it back and forwards, done your thermal modelling and all that stuff, the assumption is that that's been agreed and that's the end of it. And you can go and order your ducting for 2.5 air changes instead of 6. Is that not correct?
Well, the design was developed and then further reviewed. So that further review, along with other discussions, would inform that.
Are you aware of any discussions directly on whether the ventilation derogation should be proceeded with or not?
I am aware as I said before, that there were further discussions in 2010 with infection control and with Peter Hoffman, for example.
About this derogation.
As I understand it, yes.
Just bear with me a moment long. I think this is perhaps, I'm not quite finished this sequence law, but it might be as good a point as any to pause.
We'll take a lunch break now. Could you be back for 2 o'clock?
Okay. Lord.